Georgia pro-Trump attorney Lin Wood has potentially put his license to practice law in jeopardy by refusing to participate in a mental health evaluation requested by the Georgia State Bar Association. Now, the state bar does have some capacity to request this mental health evaluation, and if you refuse, it could lead to an escalation and even an immediate suspension of an attorney's license if they determine that clients are at risk from the attorney's actions. Lin Wood, for his part, has said that he will not participate and has even threatened to litigate against the state bar itself if they choose to go down this route. We'll talk about those rules and take a look at them in just a minute. But first, why are we here and why is Lin in the position he's in? I'm Nick Ricada of Ricada Law, a small law firm in central Minnesota. I'm a lawyer. I'm a legal and political commentator here on YouTube. So if you like analysis, opinion, and commentary surrounding legal and political issues, hit the subscribe button and hit the notification bell so you don't miss any episodes. That's why we're here. Why is Lin Wood in this position? Well, it starts with his outspoken support of Donald Trump before, during, and after the 2020 presidential election. He, in fact, filed 3 lawsuits on his behalf in Georgia against Secretary of State Brad Raffensperger. Now, all of those lawsuits were dismissed because the judge determined that Lin Wood didn't have the individual capacity to bring a lawsuit against Raffensperger over the issues that he presented. This is a doctrine called standing, and it is a pre-trial dismissal by the court that says we don't even have the right to hear this case because I can't give you any relief for anything you've stated in this lawsuit. Now, for his part, Lin Wood has disagreed with this decision and has appealed this all the way up to the United States Supreme Court, where it is awaiting a determination on review. It's unlikely that the Supreme Court will actually review this case. They have not really been willing to participate in any post-election litigation up to this point, and if they do choose something, it probably won't be Lin Wood's case. And it's basically impossible for them to change the outcome of the 2020 election itself. This would really be about how future elections are handled and how, in Lin Wood's case, how courts determine standing in the context of a post-election lawsuit. Okay? So don't look to this case from Lin Wood to come in and overturn the election results. That's not going to happen. That being said, that's probably a big part of the reason that Lin Wood is there. And some people might suggest that the allies of Donald Trump, I might suggest it, that the allies of Donald Trump have had people going after them, going after their ability to practice law, going after their professions, their jobs, their ability to publish, their ability to go to attain future work. I mean, the reason I suggest it is because there are tons and tons of news stories, some of which I've covered on this channel, about people doing exactly that for their support of Donald Trump. Lin Wood in specific, though, has a complicating factor in that some of his tweets prior to his Twitter account getting suspended were getting pretty spicy and making some people very uncomfortable, including calling for the arrest of Mike Pence as a traitor to the country and suggesting that he could face execution even by firing squad. Now, these sorts of tweets, Lin Wood has argued and pretty convincingly argues they're something called rhetorical hyperbole, which means that you can make a statement that is outside of the normal sort of scope of conversation with an idea to shock the conscience, so long as it's not a true threat. And Lin Wood didn't really say anything that amounts to a true threat against Mike Pence. Whether you like Lin Wood or not, his words do seem to fall into that rhetorical hyperbole category. And the reason we have those sorts of protections are because, guess what? We actually do get to criticize our politicians. It's kind of the purpose of the First Amendment, is to protect our ability to do that without legal ramifications. So the Supreme Court has spent really time since the founding of our country trying to figure out the limits of that free speech protection and the limits of what we can say. And they tend to fall in favor of a person who's not making a threat. And a threat is intended to threaten. I don't think you could convincingly say that Lin Wood was attempting to threaten or intimidate Mike Pence with his words. Rather, he was expressing distrust. But I don't know. Tell me what you think down in the description, because I'm rambling about this and I'd rather get your thoughts on it than hear mine over and over again. Okay. Those statements sparked a massive public backlash, at least on social media, and in fact have even led to Linwood's termination by one of his high-profile clients, Nicholas Sandmann, the Covington, Kentucky kid who was really ridiculed and destroyed by mainstream media. Now, Linwood has been representing him, in fact, getting settlements from a couple of those mainstream media organizations, but I believe there's still 6 lawsuits outstanding, and Nicholas Sandmann has severed his relationship with Linwood. And this was kind of predictable, as when Linwood made the Mike Pence statements, Nicholas Sandmann had tweeted out that those statements were not really acceptable in his opinion. And there's some suggestions that Nicholas Sandmann had even worked on behalf of Mike Pence at some point. I'm not really familiar with that. You guys may know more. But Linwood has suggested that Nicholas Sandmann has been under pressure, maybe from Mike Pence associates, to sever his connection to Lynn. I don't know about that, but maybe that's true. I literally have no idea. What is true, however, is that those statements sparked a firestorm, and that firestorm has been coming for Linwood ever since. So people are attacking his ability to practice law and to competently represent his clients. And if they are able to successfully do that, his license to practice law could be entirely revoked. That would limit his ability to do anything as a lawyer going into the future and would be a pretty devastating blow. So let's take a look at the rule they're using here. It is rule number 4-104, mental incapacity and substance abuse. Now, this doesn't mean that both of those are required. It just is, in this section, they're treated in a similar way. So, mental illness, cognitive impairment, alcohol abuse, or substance abuse to the extent of impairing competency as a lawyer shall constitute grounds for removing a lawyer from the practice of law. Okay, so just having a mental illness or alcohol or substance abuse doesn't actually disqualify you from being a lawyer. In fact, if you disqualified lawyers who had substance abuse issues, you'd be disqualifying an alarmingly high number of them. It is an ongoing problem in the profession, and it has to do with lots of things like stress and the nature of the work. I mean, defense attorneys and prosecutors sometimes have to deal with really awful realities of this world, and that can drive them to some sort of substance abuse. Now, they don't want to go through the inefficient process of disbarring a lawyer for that. They would rather them get help if necessary. But if they are putting clients at risk, then they want to protect the client. Remember, most rules around lawyer professional conduct are geared around the idea that the client needs to be protected no matter who the client is. Okay? So what has to happen next is a determination by the state disciplinary board that a lawyer may be impaired or incapacitated to practice law as a result of one of the conditions described in the previous paragraph. At that point, they can request a mental health evaluation or a substance abuse evaluation if that were proper, and then the lawyer is expected to submit to it. But like all things in law, lawyers don't actually have to automatically do what the rule says. They can question either the text of the rule or the usage of the rule. And in this case, Linwood would probably say, I'm being retaliated against for my free speech rights. I'm not mentally unfit in any sort of way, and my actions don't have any jeopardy to my clients. And there would be an argument over that, presumably in court or in front of the state disciplinary board, depending on the route that is taken. I would guess Linwood would want to go to court over it. But Linwood has also had his temporary admission to practice law in Delaware revoked over similar sorts of actions. So it's a little bit different case than that here because he's in his home state under his bar association rules, but he is still at risk, and there has been a demonstration that his statements have gone too far for at least one judge. So we'll have to see. Long story short, though, if he does go ahead and refuse, they go to Rule 4-108, which can lead to conduct constituting threat of harm to clients or public and an emergency suspension as a result. This is where the board can make a determination that the lawyer is putting people in danger and needs to be suspended immediately. Now, of course, the lawyer gets a chance to respond to this, and once they do that, it will determine if they get to keep their license or if the license is temporarily suspended or what have you. So we'll be following along as this develops. We'll see if Linwood actually files suit against the State Bar of Georgia. That could be a pretty interesting category. And bar associations, for better or for worse, I think for worse, have become highly, highly politicized. And though they do confer some benefits, the idea that a bar association leans in one particular political way in an environment like we're in right now could lead to improper disciplining of attorneys. So we'll see how that works out, and I'm guessing that would be a big part of Linwood's argument. We'll follow along. If you want to follow Linwood and his endeavors in the post-election lawsuit, here's a great place. So until next time, we'll talk soon. Peace. Peace.